So,
Yes, sir.
yes, sir.
Yes, I had all this portion, the first, the summary part, this Fowler's five rule of drafting. You may read it again, at your own places. But I'll start with the sketch or scheme of the draft document, because for us at this particular time, this is relevant. Just keep a track on the words that I am reading. It's always advisable from here, sketch of scheme to the draft. Whenever you start drafting, be it any draft, be it complaint, be it notice, be anything, you just need to sit down, you just need to sketch the outline. What happens when a client comes to you? What will be the first thing you will be asking to him or her? The first thing you will be asking him is, what is the narration of facts? So you need to sit down, you need to just jolt those points roughly on some place, and you need to sketch an outline. You cannot just write in a way like, I start writing that on such and such date in 2016 this occurred, and then I start writing a story about the things, and then I come to a conclusion. You need to be very specific, because your draft should be very precise and very elaborative also on the same side. So you need to sketch out that what are the necessary things you need to address in your complaint. So sit and sketch an outline. Outline means, okay, I'll draft this complaint in three stages. One will be the facts pertaining to the past, one will be the fact pertaining to what made those parties come in common consent, third will be the part where I'll show what exactly the offense is and how it occurred, how it took place, and fourth, I'll show the law. So this will be sketch with whatever sketch you will be uh, thinking in your mind prior to drafting, prior to sitting to draft. Because if you don't sit and you don't analyze what major points you need to address, you will never be able to complete a draft in one go. Because what will happen, Jawab, when you will be starting drafting and you don't know, you have no idea about what four broader prospect or what categorization should be there, you will be just writing and writing, and more or less the draft will become so lengthy that any other person will when it comes to their table, they'll just keep reading and they'll just not follow what exactly you want to say. So is it clear? First thing is sketching an outline. It says advisable to sketch and outline the contents of a document before taking up its drafting. This rule is suggested such as that, leave this. This rule of draftsman must be that this that. What does this that mean? This that means you need to re-rack the incidents. Whatever have been narrated to you, now you need to re-rack. What should be first? What should be second? What should be third? So, in a chronological manner, so that even a layman after reading that can get to know, okay, this is the complaint. Correct. So sketching an outline of the contents of document is necessary for the first thing. Then coming to skeleton draft and its self appraisal. What does this say? This says, once you have drafted your skeleton draft, once you have thought what you need to draft about, now you know that this is the first this is facts connected to the previous history, this is the fact which shows common intention, this is the fact, and it's all in a paragraph and all in a seriatim. Now you will draft a skeleton draft. What does skeleton draft means? A rough draft. Then you will reread that draft. Now you have to read it in a way that whatever I wanted to convey, whatever important topics I needed to convey, are they covered in this or not? Important topics, I already told you that we need to consider that fact of an offense against a person known or an unknown, and commission of an offense, and any other document or a witness you need to support with your complaint, that because of this and because of this law and this particular witnesses, this crime is made against those people. So now you will be self appraising that particular skeleton draft. Once the skeleton is prepared, first you sketch out outline, When you sit with your clients, let's assume as in a seat of a lawyer, what we do is a client comes or an aggrieved comes to us. He says, okay, draft me a complaint. What do we ask about? We ask about the facts. We say, okay, just give us a list of date of this. What does list of date means? List of date means whatever has happened since day one till the commission of an offense for which you want me to draft. Just give me a brief summary of that. He keeps on narrating, you keep on noting the important points. Now, after noting everything, you decide what is relevant and what is not relevant, because you cannot just go whatever he has told you. You have to pick and choose the relevant points. Then you make give them the importance, that okay, this point is important, so this needs to be the first point, that this particular contract or this particular thing was executed from day one. The other person, the accused whom we are charging for 420, knew about the fact that he will be not fulfilling the terms and conditions of this agreement, and just to create a fraud or forgery, he entered into this agreement. So all those things, now you will be drafting a skeleton thing, and after skeleton draft you will read it. Then special attention to be given to certain documents. There are certain documents, see, there are certain documents which we will be always taking help of while drafting a complaint, because there will be certain evidences which we need, that on the prima facie this will help us. But you need to be very specific about those documents. You cannot just merely write, okay, referring to document number 1 at page number such and such at of list of date. You will not mention that like this, because you will read that document and you will try to figure out what exactly the document says and what exactly you want to convey. For example, there's a there is a dispute. Somebody has some land mafia has grabbed a plot of land, say. Your client comes and says, this was my land and I have the complete chain of documents which prove my ownership. You cannot just merely write, okay, because of the ownership documents of the complainant, this land belongs to such and such, and the other person have entered wrongly into this land and captured and thrown him out of the possession. Forceful exit is there. No, you will have to write, as per the documents, as per the chain we have, such and such person was the erstwhile owner. After that, the sale or registered sale was taken place, then this, and at the end of the chain, this is the complainant. So by this virtue, he is the owner. And now you will establish that the owner has been thrown out of the property forcefully. So this will be your narrations. So it says special attention given to certain documents. You will annex those. Yes, Chandu.
Sir, like if apart from the documents, if we have some audio or video clip, so we can mention that as well.
Yes, I'll come to that. But if you are asking it right now, I'll just clear it here only. That yes, if you have some audio and video clips, or for audio clips, it's always mandatory that you give them the transcripts of those audios, because some trial courts where the courts where the trial proceeds, they don't have that kind of setup or that kind of facility that they can run those audios, and it's always called for a transcript. For example, you need to submit some audio clips between two parties. So they will not listen. They'll just say that you write it, you just reproduce in a written form and just give it to us along with the audio. If necessary, if it's so relevant, we'll arrange. But if it's not, then we'll just go through it and we can ready have a ready and reference for doing and that evidence.
And also, sir, the police will validate that it's like actual audio or not, or court will order this for the forensic.
That becomes a part of trial. That is
Oh,
not a part of your criminal complaint right now.
so I can.
You are just jumping further. That becomes
Okay,
a part of trial. That will be as per the liberty granted by the honorable courts.
okay. So
That if they wish
police,
to,
like police can accept that audio or video, whatever, if I want to give them,
they will accept everything from you.
but they
But
will not.
here we are talking about complaint before a magistrate. We are not here before FIR.
Okay, okay, sir. Thank you.
So we are kindly just try to stick only to the this part, that this is a complaint under 200 CRPC made to a magistrate.
Okay, sir.
Correct.
Yes,
Now
sir. Thank you, sir.
we'll again that certain documents need self special attention, that these documents cannot just vaguely be attached along with your complaint. So you need to be very specific about those documents, and special attention needs to be given to them. Then we should there are some do's and do nots. We'll just quickly brush up them. Some do's. It says, while you're drafting, reduce the group of words to a single word. If you can, if you can, one word for many. Have you, you people might have taken in your studies also when you we were in schools. There used to be one word for many. So we should reduce our drafting in such a way. We should draft it such a way that if we have to use 5 words, say just to complete one sentence, we are just writing 5 words. If its sum up is in one word, then we should reduce those particular word limit, because that reduces your word limit, and it becomes very easy to understand. Then use simple verbs. As I already told you that group of words is not addressable. Use simple verbs. Use simple wordings. Avoid running over construction. For example, if you need to narrate an incident, for example, it's an incident saying forgery. Don't say that the person did this and he then impersonated the signatures of such and such. Just write that this person did impersonation and signed this, forged this document. So limit less, you limit your words to lesser things. Then avoid necessary repetition. It says point 4, avoid necessary repetition. What does this mean? Once you have quoted up your issue fact, you should not. Yes, Banu Priya.
Sir,
Yes.
for each and every rep, we have to follow this follows principles.
Yes, ma'am.
For each and every rep, we have to follow this follows rules of principles, sir.
No, no. I'm yes. See, what I'm just sharing with you on the screen. It's a common essentials we should keep in mind. It's not about specifically complaint, but I am just trying to connect it with complaint, drafting of complaint. But you can use it in on a larger perspective while you're drafting, or some conveyance deeds, some documents, some suits, everything.
Okay.
Because it's a after all, drafting is an art, ma'am. If you can express yourself in less words, your document will not be that voluminized, and it will be easy for other also, because after reading a lengthy draft, it is presumed that most of the facts, they just go away our mind.
Thank you very much, sir.
Yes, ma'am. So avoid unnecessary repetitions. Once an incident has been quoted, you should not rewrite it, because then it creates unnecessary confusion also. Because you should be very crisp and clear that this happened on this date, that's it, khatam, move to next point. And it should all be in a paragraph numbering way. One para should contain only one fact. It should not be that we are writing multiple facts in just one line, or multiple facts in just one para. Credibility should be there. Then put yourself in the place of reader. This is the easiest way you can update your drafting skills. Whatever you are writing, if you can understand it in a very simple term, definitely the other person can. So put yourself in the reader's place also. While you have finished your draft, just read it in a way that, okay, if the person whom I am addressing, how will he or she take it? How will he or she understand it? So if it's easy, if it's credible, if it's very precise and very self-explanatory, then the document draft is very good. One more thing, while drafting and putting the facts, you should not merely just admit or omit something, because you should always think that if such and such incident, if such and such incident is admitted, what will be the after effect of this? If I admit certain documents, or if I just merely say, okay, I admit whole of the document, what is relevant? That should be kept in mind while drafting. It should not that if I admit something and it backfires on me. You should think that in advance, because once a draft has been prepared, it has been filed, then there is no way you can withdraw it or amend without the proper channel. Then it becomes a bit difficult to take a U-turn in that thing. So the best exercise for this is place yourself in the reader's shoes. So now coming to our draft side. Now, facts related to the offense, description of the crime, keeping in mind the basic drafting parameters we just did. I'll share it with you. You just go through it again. If there's some other confusion, then we can just have a discussion on that also. The important ingredient in a complaint is cause of action. Without a relevant cause of action, we should not draft anything. Then this fixed court fee has already been discussed in prior. Then at the end, there comes the prayer clause. What we are seeking from the honorable court. So I'll tell you why I have kept two prayers. Prayers can be multiple, but it cannot be on an open end. You just need to summarize what exactly the relief you want from your complaint. So it is there. We generally write, it is therefore most humbly requested that this honorable court may kindly take prompt legal action against the accused person for commission of the alleged offences. So in the first part of the complaint, you have already discussed what were the offences that have been committed. Now, sir, Chand Babu sir, what you were asking me at the time of the start of the class, that whether we should write the sections or not. Yes, we should write those sections in our complaint here,
Yes,
because
also
it's
I
a
wanted to ask, sir, on which part we should add, like at the at the end or beginning or bottom part, where we should add that section?
see, that is up to you. That is up to you when you just write the facts. You should write the facts like this occurred, this amounts to section such and such, this
Like
offense
on okay, okay, sorry.
on the first initial only. When you're writing the facts,
Okay,
because it's a complaint,
yeah,
you know that complaint is made before a magistrate. You know
yes,
that he is very well versed with the sections of IPC, correct? Now,
yes,
the more you will be assisting him or her, the more interest he will take in your complaint. For
okay.
example, if you write that there occurred a robbery and write the section of the robbery and give a brief that because of this fact, the ingredients of robbery are made. Now you need not to explain why you are charging that allegation against that person. So here it becomes relevant that you write all the sections.
It's also that police will remove that section.
No, no,
Might
no. It's a complaint case right now. No? It's a complaint before magistrate. You are just confusing it with
oh
FIR.
no,
Don't
no, now
confuse
I
it.
got it. Yeah,
Just
now I
forget
got
about
it.
FIR.
Yes,
Just forget about FIR. It's only a
yeah.
complaint before a magistrate.
So police will accept
So,
anything, whatever I have to give.
see, I told you that police cannot pick and choose words or
Yes,
information, whatever your informant is giving.
okay.
Police does not have that right. Police will record verbatim whatever you have said. Have you ever heard about when you are giving some complaint, or when you are telling something to a policeman, he is just recording something. He writes Tahrir Bayan. What does Tahrir Bayan mean? Tahrir Bayan means the informant, as deposed by the informant, I am writing it. It's all his wordings. It's not mine. If you go, so let's waive this FIR part right now. Just come back to the complaint. In complaint, yes, we should mention the sections also. Like we are writing the facts, we should specifically write that this particular fact initiates proceeding against the accused person under such and such thing. So now, alleged offenses over here, we are coming in the prayer clause. Alleged offenses, and we can add offenses under section such and such, such and such under IPC. We need this honorable court to take action against the accused persons. Correct? This is one main prayer. But we should not limit ourselves only to this. If we just See, there's a presumption while we are in litigation. What happens is, whatever we pray, court will only specifically, minutely observe and deal with that only. If we say, kindly grant us this relief, court will not go beyond that till the time there's an exceptional case. But general tendency is that you have prayed for this. Okay, this relief is made or may not. So they will just stick to that thing. But when we keep an open end over here and write prayer B, any other directions which this honorable court deems fit in the interest of justice. So now this gives an open end to the court also, that other than prayer 1, we can grant any other relief, and that is not specifically bound in goalpost things. You have not restricted your prayer over there. Now you can say, okay, not if not any action against accused such and such under this. Okay, any other action specific. If a surveillance, for example, if a investigation is to be made or a surveillance is to be kept on them, you can say, because of prayer B, I am eligible for that. Otherwise, what will happen if there is only prayer 1, prayer A, that under such and such act sections, please take necessary action. They will say nothing is made out, we will not take any action against them. But then what? Relevance of clause B in prayer is very much important. So you should always add this. It should be a thumb rule. Every draft means every suit pleading, any document placed before the judicial authority where you are seeking any relief, always seek this relief. Any other directions which this honorable forum, court, commission deems fit in the interest of justice. This should be a thumb rule. Just summarize it. There is no major explanation other than this. That this will give you an open end, that if your main prayer is not accepted, at least you can seek any other relief also at a later stage. You will not bow down only to that particular extent of one prayer, because facts and circumstances change. So now, then complainant, it needs to be signed by the complainant through advocate also needs to sign. Then date of place of filing and date, this is very important. Then affidavit and verification of the present complaint by the complainant. This should be, if we are referring some documents also, then we need to draft a list of documents also. Now, how this is relevant, you will be asking me why a list of documents needs to be addressed. Because when you will be writing the facts over here, facts related to the offense, for example, you are having certain documents which you need to address to the court. You will say that on such and such date this document was executed. Now a copy of that document is annexed as annexure 1. Now this annexure 1 will come in the list of documents page. You will write the page number, so it becomes a kind of a notebook. When you are reading it, you will just go to the index part, you will see annexure A, page number 13, just page number 13 of your paper book. So it is just for the ease of the person who is disposing of your complaint, who will be dealing with your complaint. So this assistance is to be given. That list of documents, yes, list of witnesses is also needed. As I told you earlier, that under section 201 or 2 CRPC, it says when a written complaint is placed before a magistrate, what are the duties of the magistrate? Or magistrate will just take up the file and try to examine the complainant and the witness. So you need to disclose list of witnesses also. Till now it's clear. This is a basic draft, so it changes from case to case. Is it clear till now?
Yes, sir.
Okay.
Sir, is there any minimum or maximum words? Like,
Yes.
is there any minimum or maximum words we should write in a draft? Like,
See, if I share a book with you, and that If I share, leave about a book. If I narrate you an incident by writing it down on a piece of paper, and it becomes a voluminous book, will you be interested in reading it?
No, of course not.
This answers your query.
Uh,
And see, I told you while drafting, you should keep the human behavior in mind. In my previous lectures, also, I told you that while we are drafting, we should keep our human behavior also in mind. For example, we are giving a information to a police officer. He is already burdened with the work. He is having overloaded work. He is already going to investigation on the ground zero and having all those activities are the other official duties which he is fulfilling. So if you give him a voluminous complaint or an information, he will not be able to process it. There was an incident, I'll give you a live example what happened. There was an incident where we were to complain about a infringement in patents. Now what happened? We drafted a complaint and we just wrote about patents. We went into multiple pages telling about what the patent is, what the derivatives are. We gave it to the police personnel and said, kindly take note of this. For a couple of months, he could not even understand it because first, this needs a specific knowledge. Client had disclosed it to us, so we were able to write it. But who will explain it to him? So then he told us that you just give me a simpliciter thing, which is easy to understand that what exactly the crime is and what has happened with you. What is the grievance? So there is no specific word limit, but it has to be decided by you, keeping the human behavior in mind. Now you are here before a magistrate. If you will write a novel, the magistrate has in a day to deal with hundreds of complaints. How will he take your complaint? He'll say, okay, this is a very lengthy one, give me a brief synopsis to this, or otherwise just help it out. Then you will also be confused that from where to start and where to end it. So just keep it less and crisp and brief. That's why I said keep first note down the points. Second, create a skeleton draft. Third, self appraise it. The skeleton draft needs to be self appraised by you. If you are satisfied, yes, this is okay. This needs no addition, no subtraction. Then go further. Give special attention to the documents you have referred to, or special attention to the facts you are mentioning over there. And at the end, just place yourself in the feet of the reader. Here you have to see what a magistrate will be dealing it, how it will be dealing. If there are complex terms, if there are complex paginations, if there is no free flow of thoughts, nobody will be able to understand. And the moment they will feel that they are losing interest, they will just drop your file. Okay.
Also, sir, like you said, we should keep in mind while drafting like any notice. So, can we draft a notice in a color printout, or it should be always in black and white? Like
See,
color will be more interactive, and
I'll tell
the
you that there are rules and regulations as per the different court. Delhi High Court rules is different. Supreme Court filing is different. See, when you come to the drafting part in Delhi High Court and Supreme Court, we use A4 size papers. Now it has been allowed that both side prints will be allowed. Earlier it was like legal size paper, only one side print with paginations, with uh, gap of two between the lines.
okay,
And there were like you need to keep margins on both the sides for judges to take note, because if there is no margining, how will they just while taking the file physically, how will be they just able to write or note their important points? So everything has to be kept in mind before drafting. It's also the paginations, the margins, the marking setups, the page you are using, everything has to be kept in mind. That's why I decide that you need to observe the human behavior also while drafting.
okay, sir. Thank you.
Sir, sorry to interrupt you.
Yes, sir.
Uh, exactly after explaining whole thing about drafting, uh, convey conveying the right message
Yes,
appropriately. That's
correct.
it.
That's the only theorem we can use.
Okay.
So
Yes.
on the very opening statement, I said that there is no set format, but you need to regularize the word limits. You need to think on the other side also, that whom you are referring this particular document, how will that particular person deal with it?
Yes.
So
Thank you, sir.
essentials of drafting, basic essentials are these. We have already done while we were drafting notices, while we were dealing with complaint case earlier in the previous lecture. So there's nothing more to add this, because it will surely create a confusion in your mind. I'll share the documents where, see, I'm sharing with you the documents. One is to complain to a magistrate. That is the today's topic. But as Chand Babu also said that when we write some complaints for our clients, so I'll share that also. The rules of the draft are same, somewhat same, because drafting skills are basically these. We can just have a discussion, never ending discussion over drafting, that will go never open ended. So the basic drafting needs to be this, that we need to paraphrase ourselves, and we just need to cut short things in a very precise manner. Any other query for this, because we have almost covered it now,
Sir,
nothing must
yes, one more question, sir. Sorry, sir.
happen. Yes.
Sir, can on a draft can we take a signature of a witnesses if we have witness
I already told you that list of witnesses have to be filed separately. So
separately? Okay, okay.
nothing
So
because
on a
on a draft only a complainant can sign, and if it's filed through counsel, his counsel can sign.
okay, okay, sir.
So list of witnesses is given in advance. Thereafter, if addition or subtraction of witnesses is to be taken, then you need to take permission from the honorable court.
Okay, sir. Thank you.
Have you guys gone through the previous narration, that particular situation I gave it to you, that employee employer situation we were discussing lately last, that an employer employed an employee took away, ran away with the vehicle, and later when it was asked, the employer said, I was not being paid, so this vehicle is in lieu of that. So what does it come in? Does it come as a criminal offense or a civil dispute? I think you have not gone through that. Let's start this then. How does it just explain, how does this come as a criminal offense? He says that he has not paid me wages, and by virtue of not paying wages, he just took away the vehicle.
Am I audible, sir?
Hmm.
Yes, sir. I was just thinking, like in a layman and a logical way, like the if a person is not paying you wages, that is not the remedy that you go for, where you steal his
No,
vehicle and then you hold it ransom.
employee's defense was that employer gave it to him. So you just gone a bit. Yes, Shreya.
Sir, I think it is a criminal offense because though he was giving the reasoning that he had taken away the bike because he was not paid, but the thing is that he took that bike without any permission or without any possession, and that was a movable property, and that was theft, and theft is considered as a criminal offense. That's why it is a criminal offense.
What if I am the employer, you are an employee, I am not paying you wages, you come to me, I say, okay, take this vehicle, I'll just do the necessary request. It's on oral arrangement. How will this commute a criminal offense then?
Sir, there are better provisions. There are legal provisions where I can go to demand my salary from my employer. That doesn't mean that
In those,
I can
yes,
just.
you see,
Oh,
in those cases, what happens is, I was just asking you. I'll just not take you much of time because it's 8:30 or almost. Yesterday also we stressed the class. In those cases, what is generally done? There's a concept of case diary. Case diary is a formatted noting book with a police officer, and the format is as per the state provides it. In those cases, there otherwise what will happen, because an FIR becomes a document wherein you have to show investigation in 24 hours. If on such disputed facts police goes and registers an FIR, then it becomes difficult for them also to track, because before in within 24 hours they have to present it before the magistrate, and then they have to show their day-to-day assessments also. So it becomes for them, it has been kept where a case like such cases are coming up with to them, where there is a tinge of civil dispute also. What they can do best is they can just note it in their general diaries, and later on they can just investigate it, and if on the later part they feel that there was something in this case, then they can refer it for further proceed. I was just asking because it's for an FIR, they need a very subtle, they need a very hard kind of thing that yes, this has occurred and it should be writ apparent. I'm just to clear that point. So you have gone with your assignments also. You have done your assignments.
Which assignment, sir?
yes, sir. Sir, that notice assignment is completed.
Notice part is completed. Any difficulty in that?
No, sir.
Okay, good. And what about the affidavits? And have you gone through those affidavits which were shared?
Yes, sir, we have looked on the drafts.
Not look. Have you just tried to understand, tried to see what exactly the drafted document was and what it was conveying? And those 138 notices, you went through them, whatever I had shared with you.
No, sir, not yet.
Not
Generally,
yet, sir.
you have those notices with you. The I shared in PDF form, shayad. Yes, PDF form they were, because they were having notices. They were having replies also. So more or less, the drafts would be on that particular skeleton format only. Whatever you will be drafting. Chaliye, no other query today. Good. Let the host then conclude the class. Is there anyone who can conclude? Because I'm also not aware about what is to be done tomorrow.
Sir, as per schedule, those we receive from LeDroit, it will be the 4th of May. It will be civil suits.
4th of May is civil suits.
Yes, sir. As
Let
per
me
schedule.
let me just check. Uh, Civil suits. I'll just ask you people randomly, just in a general for information for mine. That uh, have you just gone through some moot courts or something in your law school time?
Yes, sir.
And those case laws were, and all were shared with you.
Yes, sir, repeat.
Have have what I was asking is that have you argued some moot in these cases where civil disputes and all?
Yes, sir.
Yes, sir.
Okay, okay. That means that you must be aware about the basic structures of this civil suits and all.
Yes, sir.
Yes, sir.
Chalo, let's. So we'll be just brushing up the basics of drafting. Then we'll just go to the civil suit part, because the only thing you need to know about the civil suits is that civil suits are those wherein you need to satisfy each and every averment and allegation, mostly with certain documents, because that is the main principle, which is untold principle about drafting a civil suit. You cannot just go on hearsay evidences in civil suit like we do in criminal. We cannot do that in civil. So this is the basic thing you need to understand and keep in mind before sitting for understanding the way of drafting of a civil suit, that everything has to be substantiated by a certain document. So let's end the class then. It's anything else left over?
All set, sir. Thank you so much.
Okay.
Sir, I have a question, general question.
Yes, yes.
Actually, I attended a today hearing for insurance company, and I am here some word LC. What is the meaning of LC in that case?
Sorry, I couldn't get because of some network issue. You attended a, class
Hearing.
hearing. Okay.
Yeah.
Huh?
Insurance company hearing, insurance claim hearing is a case.
Okay.
I am hearing some word LC over there. What is meaning
LC
of that?
means local commissioner.
And what is the duty of that, sir?
Local commissioner is a setup, is a officer of the court nominated from the court itself or from the designated list. It's a lawyer generally who is assigned with a particular task on behalf of the court. For example, I was a local commissioner in an IPR infringement case where we had to raid the premises, and it was a infringement of a software. So we had to raid over there because of court cannot go to the premises. So they appointed me and said that you may go with the petitioner and see, look into this, that is that particular pirated software being used or not. So we went to, so this becomes local commissioner. Local commissioner means a person nominated by a competent court for taking a particular work on behalf of the court.
Okay, sir.
You attended in an insurance hearing. It
Yes, sir.
might be a MACT case,
Yes, sir.
and in MACT cases, recording of evidences sometimes it goes before the local commissioner because it's a lengthy process. In MACT cases, there are a number of witnesses. Say, generally, I have seen, because I myself do MACT cases, so there are list of witnesses goes beyond, on an average, like 10, 12 witnesses, because there is an FIR. The person who is writing in the FIR, that becomes a witness. The person who was on the crime, who was on the accident site, becomes a witness. The person who has received the dead body or who has received grievous, or the doctor who has done MLC becomes an witness. So recording those evidences becomes a bit tedious work in the court premises. So they appoint a LC in this.
Yeah, okay, sir. Got it, sir. Thank you,
Okay.
sir.
Thank you. Welcome. Yes. I think it's over. Then let the team take it further. And
Thank you, sir.
Thank you, sir.
Thank you, sir.